Good morning, everyone. We're just going to take a minute while everybody filters in. We're actually going to launch a few poll questions to sort of get a sense of what has brought folks here today. So that will be launching in a minute, and we'll just take a few minutes to let folks get in and get settled. So I'm seeing lots of familiar colleagues and friends joining. Thank you so much for joining us here. You'll see that there should be a poll popping up on your screen with some icebreaker questions. So feel free to take a minute. Those are optional, but we were just curious to learn about what has brought folks here today and how EDI is rolling out in your respective organizations. Okay, I'm seeing so I'm seeing lots of folks coming in. So I think we're just about ready to go. And there should be a function for participants to leave questions for us. So if you aren't seeing that function, well, then just let us know. But I'm just going to make sure that that's set up as we go along. It should be on the bottom of your toolbar under the Q&A function. So there should be sort of two little caption boxes, and it says Q&A, which allows you to leave questions throughout the session. And I think we'll leave the poll open for a few more minutes, but we can look at that soon. So without further ado, my name is Boychuk, and I am delighted to share the virtual stage with Maya Fernandez, my colleague at Nelligan Law. We're both on the labor and employment team. And we are recognizing today, and we are acknowledging that we are joining you from the unceded Algonquin and Anishinaabe territory. The peoples of the Algonquin and Anishinaabe have lived on this territory for millennia. And as lawyers, we actually recognize our special duties under Call to Action 27 to engage in human rights and anti-racism training. So we do feel called to do this work, not only from our professional obligations, but also our obligations under the TRC and our special role that lawyers can play in advancing these important issues. Okay, so without further ado, we're going to sort of start to roll into this content. I'm going to ask my colleague to move to the next slide. So I just want to share at the outset, we always have to do this. We have to share that this is not legal advice. Really, we're going to be giving informational and educational content today. If you do have specific legal questions, you really want to be speaking with a lawyer about those. But we're going to do our best to give you practical tools that you can use in this work going forward. We can move through the next slides. Okay, I know my colleague will
Sorry, guys, it's just a little slow on my end. I'm just trying to move it forward here.
No problem.
We can see the mouse is trying to do something.
Yes. Okay. No problem. The slides will catch up to us. So in the meantime, I'm just going to share how we sort of see this work fitting into this larger web of equity, diversity, inclusion, and anti-racism that so many organizations across the city have rolled up their sleeves to advance these sort of transformational objectives. And so how do employment lawyers fit into that work? So that work probably has started with working with a consultant, doing an organizational evaluation. You may have a staff committee. You have all kinds of activities going on towards making these changes to bring EDI to the center of your mission and to make it a reality. What happens though is when you're operationalizing those changes, you tend to encounter novel questions of employment law. And so Maya and I have been talking about this for quite some time. And what we really wanted to do is to provide practical tools and sort of a proactive approach of here's how employment lawyers can be a part of this change in a proactive way, rather than putting out fires on the other end of things, and really be a part of the solution and actually accelerate the kinds of changes that you want to see in your organization.
I'll just add to what you're saying there, Claire, in terms of the proactive is that, what we see when people come to us, whether that be employees or employers, is that oftentimes something has already gone awry. And so we thought, what are the things that we can do to help build a stronger foundation and get to some of these things before they become issues that come to us in more of a crisis state?
Great. Okay, so we will be unfolding and launching a sort of 3-part series over the rest of the year. So the first one is focused on recruitment. We're sort of mimicking the life cycle of an EDI process. So the first session and our content today is recruitment. The second is on accountability and conflict. So those are all the kind of channels, policies, processes that you need established in your workplace to support these changes and make sure that conflicts are resolved in a way that is proactive and supports your broader goals. And the third is thriving for the long term. So these are, again, the sort of employment law infrastructure that you need set up in your workplace to make sure that you can really achieve systemic change and be that sort of leader in the field that you want to be in 3 or 5 years from now. So today we're going to cover the job ad, things to think about at the very beginning of your recruitment process, the kind of language you want to be using and what you want to avoid. We're also going to talk about evaluating applications, interviewing, decision-making, and we really hope to have time at the end for questions.
That's great. And if you have questions, feel free to put them into the chat box throughout, and then we'll turn to those at the end. So, who are we, and also who are we not in the equity, diversity, and inclusion space? I'll probably use the term EDI for that. We see a lot of consultants. We are not those consultants. We are employment lawyers. So what can we do? We can provide legal advice. We can advise you on relevant legislation, how that legislation applies. When there are changes to legislation, we can talk to you about how that new legislation applies. We can draft, review, update your policies to make sure that you're upholding your legal obligations. Obviously, the legal obligations are sort of the floor. Many employers want to do more than their legal obligations, and we can also talk about, how do you improve upon those things, and how do you be a great employer? We can also provide training to you on legal topics. So in other words, we're really coming at this from the legal lens. EDI consultants perform a slightly different function. So Claire spoke a little bit about sort of the life cycle. EDI consultants can do an audit of your organization to look at strengths and weaknesses when it comes to EDI. They can do staff training and workshops on topics that definitely go well or are different than the legal lens. So I've given the example here of bystander intervention, but they can also be providing training on what is racism, how does racism look in the workplace, these sorts of topics that aren't necessarily legal in nature, but are more social in nature. And they can advise more holistically on how to improve EDI in your workplace. We think EDI consultants are great, and if you don't have one, you should absolutely look into that. And we just want to sort of distinguish what role they do and also what role do we do there. You can flip to the next slide, Hannah. While we wait for that, context and jurisdiction. So we're not going to get into the weeds of any legislation, and that I'm sure comes as a relief because that can be dry content. However, it is important to understand a legislative context. And the first question that we ask in any employment relationship is, what jurisdiction are you in? Because the jurisdiction that you're in determines the law that applies to you. So are you in Ontario or are you federally regulated? If you employ people in Ontario, you're most likely governed by the law in Ontario. And we've set that out here. So that's the Ontario Human Rights Code, the Occupational Health and Safety Act, the Employment Standards Act, and the Pay Equity Act. Those would all be applying to you. However, there are situations, of course, where federal law applies. Examples, we're based in Ottawa, so the federal government, the public service here, a large employer where the federal law applies, but also federally regulated areas such as air transportation, banks, telecommunications. And if federal law applies, then the relevant legislation that you'd be looking at is the Canadian Human Rights Act, the Employment Equity Act, as well as the Canada Labour Code. We're going to use the term protected grounds a lot in this presentation. That's language that's used in a lot of human rights legislation. And basically what that means is these are the categories that are protected where you cannot discriminate based on these categories. There are slight differences between the language used in the Ontario legislation compared to the federal legislation. However, there's also a lot of overlap. So in general, we're looking at you cannot discriminate based on age, race, sex, sexual orientation, your family status, or disability. Given the time constraints of the presentation today, we're mostly going to be talking about what options exist in Ontario and what are the programs that exist in Ontario. However, Claire and I both practice in both Ontario space as well as in federal labor and employment spaces. So if you've got questions around that, we're happy to answer those here, or also, we'll make sure you have our contact information. You can follow up with us about that. So we'll mostly focus on Ontario, but we're happy to talk about federal. So what can employers write in a job ad to attract diverse candidates? In general, you want to ensure that your job advertisement doesn't discriminate on those protected grounds that we just mentioned. So you don't want to say, obviously, only men apply to this position. That would be a very clear case of discrimination right from the outset of your job ad. But I've given some language here that any employer could use where you're saying, we welcome and encourage diverse applicants from various equity-seeking groups. We've listed those here. There's actually a lot of research around how a well-written employment equity section of a job ad attracts more diverse and more qualified candidates to a job posting. So even though this is often sort of the bottom of a job advertisement, it's extremely important language, and language where you should take some time to consider who is it that we're attracting when we write this section, and who do we want to attract. Also, in any job process, you're welcome to include a statement, if you have one, on anti-racism or anti-oppression or equity. A lot of organizations now have this sort of statement on their website. You can put that in your job advertisement as well. That can be a really valuable tool to just sort of set the tone of, this is an organization that cares about these things. We care about it. We're letting you know we care about it from the very outset, which is in this job ad. So, okay, great. These are the things that any employer can do. But what if I specifically want to target diverse candidates? What options do I have in the context of EDI to hire those specific candidates? There are two streams that exist in Ontario. The first is called special programs, and the second is called special employment. And these are both found in the Ontario Human Rights Code. So I'll speak first about special programs, which is under section 14. And this exists, the purpose of this section is twofold. The first is to protect affirmative action programs from being challenged by people who don't experience disadvantage. And the second purpose is to promote substantive equality. So under this section, an employer can create a special program that exists and targets a group of people that's been historically disadvantaged. In order to create this program, the program has to do one of three things. It either has to relieve hardship or economic disadvantage, or it has to help disadvantaged people or groups in achieving equality or equal opportunity, or it has to eliminate discrimination. Now, the program does require some work because as a best practice, there should be a clear rationale for why you're implementing this sort of program and data or evidence to support the need of this sort of program. So the example that I've given here is the government funding job program that combats youth unemployment, where they're limiting the hiring age to, say, those under 25. Clearly, that would be discrimination based on age to say no one over 25 can apply. But you've built this special program based on evidence that shows clearly that there are large issues in terms of youth unemployment. And this is a program that we've created to target that specific issue. We actually don't see Section 14 used all that often. What's much more common is the second stream, which is special employment, which is under Section 24. And so special employment allows for a religious, philanthropic, educational, fraternal, or social or institution or organization to give preference to certain employees on code-protected grounds if they're serving a specific clientele. So the classic example in this case is a women's shelter giving preference to hiring women. That would be allowed under Section 24. In the last year, we saw a case go through the Human Rights Tribunal where the Catholic School Board was requiring applicants to be of the Catholic faith. The Human Rights Tribunal said, yes, that's discrimination in that you're requiring a certain religion. However, that's allowed under Section 24 because this is a situation of special employment. So in that case, they were allowed to say, yes, you must only be of the Catholic faith. This is the Catholic School Board. So in the next slide here, I've given a little bit of example language on what could be used in a special employment situation. So Wabano is an organization in Ottawa that serves Indigenous folks in terms of healthcare. And in this case, they're saying, yes, we invite people who fit into various categories in terms of those with disabilities and members of visible minority communities. However, we will give preference to candidates of Indigenous ancestry. So given the clients that they serve and given the organization as a whole, under Section 24, special employment, they would be able to put this sort of statement in a job ad to specifically target a group of people.
Okay. So you've written the job ad, the process is advancing, and you may be wondering, what can you ask candidates to include in their application materials? Now, a lot of the time, this is coming up more recently with employers who have looked at their staff. They're trying to diversify. This is coming from a good place. They actually want to perhaps count how many racialized candidates have applied for a specific posting and use it in their own sort of internal accountability. Or it may be simple sort of bureaucratic processing of applications that these issues come up. But what you want to keep in mind is that generally you should not be asking candidates to give their age, their immigration status, religion, race, gender identity, or family status in an application. There are obviously going to be exceptions to this. If you're applying for top secret security clearance for a federal government position, then you're going to be in a very different stream. So this is the general rule. We always say for very specific case, you're going to want to get legal advice. but you should not be asking for this kind of information. But if you're trying to get context on, how does this candidate, what kind of lived experience, what kind of formal training will they be able to bring to questions of equity in our organization, then that's what you should ask for in the cover letter. So when you pose the question in that way, you're giving the candidate the freedom to disclose what kind of information they want in a way that isn't intrusive. So that's the sort of general default rule. Now, this does get a little bit more complicated. So we'll just move to the next slide. So all employers have a duty to accommodate. And I think a lot of employers are really familiar with this for existing employees, but it may not be top of mind in the recruitment process. And I think part of that is just that once you need a new team member, you usually need a new team member now. And so the process sort of takes on a life of its own. But really, the duty to accommodate starts very, very early on. And so as an employer, you need to have an accommodation policy in place, and you need to communicate that to prospective candidates so they understand how they can disclose their needs that need to be met during the process. And of course, this has to be a 100% confidential process. This is sensitive information that candidates are disclosing. So you want to make sure you're handling that with care and sensitivity. So accommodation, you don't have to do exactly what the candidate asks you to do. If I say to my employer, I'll go to an interview, but only at the Chateau Laurier, there's no requirement for the employer, obviously, to meet that need. But what they do need to do is offer reasonable accommodations that respond to a protected ground. So I'm going to give some practical examples of what this could look like. An employer has to accommodate to the point of undue hardship. That's a legal threshold. Again, if you have very specific cases, of course, you're going to seek legal advice on that. But generally, it's important to note that a little bit of business inconvenience, that's generally not going to meet the threshold for undue hardship. The courts expect that this is such an important objective. It's a human right, and that there are going to be some sort of give and take, some flexibility and some inconvenience even that may be part of that process. So I'm going to give some examples of physical accommodations for disability but there could be all kinds of different accommodations for family status, for religious belief. There are all kinds of different accommodations that can come up in the hiring process. Some sort of practical things that could come up. You have a candidate that discloses that they have a visual impairment, or that the actual physical space where the interview taking place is not somewhere that they can actually access. So you want to make sure that from the very beginning, you have strategies in place to reduce these barriers so that you're not losing really talented people who could otherwise be part of your organization. Okay, so you begin evaluating applications. And I think for this section, we're just going to do some scenarios to make some of these more abstract concepts a little bit more concrete and interesting. So the first scenario, and I think, when Maya and I were talking about this, and what comes up so often is that you have these wonderful people, wonderful teams, and it's really in these moments of expediency where the business needs are pressing, where you have tight deadlines, that so often these principles of sort of accommodation on the one hand and your existing legacy process start to bump up against each other. And so that's where you need to really watch out for those sort of quick decisions that get made, but that can have lasting impacts and send you in a direction that you really don't want to be going as an organization. Okay, so here's an example. You're sifting through applications. You noticed a qualified candidate with no ties to Ottawa or even Canada. And you may be an organization that has struggled with retention. That's been a theme throughout the last few years. And so you think, well, you know what, this candidate, I'm not convinced that they really have a strong footprint in the community. And I only have 3 interview spots. They seem great, but I'm just going to take them off my short list. So you want to take a step back and look at, have you just disqualified someone for something that really has nothing to do with the merits, the job description, and the sort of merit that they bring to the process? And if that person walks into our office and says, look, there are a whole bunch of different things that happened through this employment process that really make me wonder, was I excluded because of my immigration status? Do I have a claim? That's something, if we look, it's going to be fact driven, but if we look at everything that's happened and we start to wonder, that person may get the legal advice that they should bring a complaint to the Human Rights Tribunal. And whether or not that was the reason, if that's their perception, that claim could be advanced and it leads to liability and it leads to reputational damage. So it's really important to have these sort of considerations top of mind and to be transparent about your process as it unfolds. So I'll give you another scenario that kind of fleshes this out a bit more. You've got an applicant, and these are based on reported decisions. These kind of scenarios that we're giving you are from reported decisions from the Ontario Human Rights Tribunal. So you can see the kinds of issues that come up. I know a lot of folks have cited different stats, but basically a huge number of the human rights cases in Ontario actually come from the legal workplace. So it can have a really big impact on society if we can get these things right in the workplace. So here we've got an applicant who's progressed to a second stage of a recruitment process. There's a 4-person hiring panel, so there's probably been about 100 emails scheduling and organizing to get everyone to come together for these interview dates. Huge business expense involved in a recruitment process. At the time of the interview, the candidate discloses that, this is actually an important religious holiday. And so they ask that the interview be moved 1 day forward because of this holiday. So the hiring manager says, yeah, we can do it, but this is really going to be a pain going forward. Like, we're going to have to reschedule things all the time. And ultimately, they aren't offered the position. So again, if this person walks into our office, gives us the whole sort of universe of facts, everything that happened to them, are they going to wonder, was I disqualified because of who I am? Was I disqualified because I wasn't able to sort of do what others were doing? Now, if they had asked that the interview be moved a month later, that would be a different situation. But if it's a small accommodation, if it's a reasonable accommodation that allows them to express their faith, then that's something that employer really needs to respect as part of the accommodation policy. So these sort of scenarios should be setting off alarm bells and trying to sort of illustrate the proactive steps that you can take to avoid being stuck in these situations. So a few sort of big picture takeaways. I think we've all heard a lot, and hopefully many of us have already undergone many, many trainings to notice assumptions and biases. But what we really notice is those assumptions and biases, they operate in moments of business expediency. So those are the moments that you really need to put the microscope on your preconceived notions, on assumptions, and on how you're going to manage when they come into conflict with business imperatives. The second is the candidate's perception matters. So it's not just about making sure that everything you're doing has a causal link and is sort of driven by a skills-based analysis. It's also taking the time to make sure that you're communicating that process as much as possible so that candidates and employees really have confidence in your process, because that's going to play a huge role in reducing these kinds of conflicts and reputational damage that can flow from them. And the third is making sure that your team understands that the duty to accommodate, anti-discrimination, anti-racism, all these things are a legal duty. They're not a nice to have, they're a must have, especially right now where there's so much more recognition about these important objectives in the workplace and across society. So One of the number one ways to make that happen is to make sure that from the very top levels of leadership in your organization, there are dedicated resources so that those that are on the front lines of these processes, the hiring managers, they have the tools they need to sort of operationalize these changes throughout the life cycle of the recruitment process.
All right, so the final sort of substantive element that we're going to cover is what kind of information can you or can you not ask in an interview? So similar to what Claire mentioned in terms of what you should not be asking in application materials, generally, you should not be asking candidates to provide information such as their age or immigration status, religion, race, family status. I've put a list of questions here that may be considered to be in violation of the code. And some of these may be extremely obvious to you in terms of avoid questions. In reality, some of these things actually come up quite innocently in sort of the small talk at the beginning of an interview. So, for example, asking someone whether they have kids or not may be just a benign statement that you're using as an icebreaker because, you have kids and that's a shared common ground. That could be seen as an inquiry into family status, and they may be interpreting that as, well, I didn't get the job and they asked a lot of questions about whether I had kids, so maybe they thought I was too busy, and maybe I was being discriminated against because of my family status, which is a protected ground. So, I've put these there to sort of get them into your mind as to things that may come up even very innocently. There was a somewhat recent case at the Human Rights Tribunal where an employer asked a prospective candidate, so where are you from? And he said, oh, I'm from this specific region in Turkey. And the employer said, oh, I'm surprised you don't look like you're from there. And your accent doesn't sound like you're from there. That could be seen as just, common ground. We're both from Turkey. I was just trying to have this casual conversation. And, on the street, that may not be a major issue. The Human Rights Tribunal awarded damages and found discrimination in that case based on those questions that were asked. So mindful that some of the questions that you ask in the interview and also sort of in the lead up to the interview may raise flags in terms of human rights discrimination. In the right-hand column here, I've put some questions that you could consider asking. So again, we've talked a lot about the value of lived experience and how with these questions that we're asking about how do we make a workspace more welcoming, more diverse, how do you ask questions that provide someone an opportunity to give that information? So, the question I've given here, describe a situation where you had to work within a culture that's different than your own. That's an open-ended question that allows candidates to provide information about their lived experience and share that with you, and may provide you with a lot of additional context as to, oh, that's the skill that I hadn't thought that I needed, or that's bringing up something different that would be a great addition to the team. So these sort of open-ended questions can be really valuable to get at some of the lived experience elements that maybe you really want for your team for any number of great reasons.
Okay, so that was our whirlwind tour. We started with the context. We really have focused in Ontario today because it just gets a little bit too tricky to pack in the federal content as well. But as Maya mentioned, that's a large part of our practice here in Ottawa. And so we will happy to answer further questions or share resources or speak with us after the webinar. But we focused on Ontario today. Things to get right in the job ad, whether you're working with a specialized program, a specialized stream, or really just generally reducing barriers for all applicants under the Human Rights Code when it comes to evaluating applications, some pitfalls, and in interviewing and decision-making, the kinds of things that you want to have top of mind to meet your legal obligations. So I'm starting to see some questions filter in the chat. I think we have a few resources to share. And what we're also going to be doing is my wonderful colleagues are going to be sending out to you a toolkit that Maya and I have prepared. It's just a short sort of 2-pager with some key takeaways from the content that we've covered today. There are some wonderful materials that are available online that expand on all of these topics. We could probably spend a week together talking about substantive equality and formal equality and all these wonderful topics. But I will now let Maya perhaps choose a question or two from the chat. And I just really want to thank everyone for joining us here today. And we really hope that we'll be seeing you at our next series, our next webinar in the series, which will be coming up in just a few months. So you will receive an invitation to that if you've been joining us here today for this first session. So, and I'm seeing, okay, wow.
There's some really great questions here. And I just echo Claire's sentiment of thanking you all for attending. And on the follow-up sheet, our contact information will be there. So if you want to reach out to us directly, we also welcome that. So I'll just answer the first question here from Karen regarding the example from Wabano and whether they would need to, or would I recommend that they specifically welcome disabled and racial minority individuals. It's not something that they would need to do. But yes, that is something that I would recommend. Again, like I said, in that sort of space that a really well-written employment equity part of the job ad helps to bring in more qualified candidates. So yeah, I think that there's no harm in providing that welcome to individuals to apply. Again, they don't need to, but I would say yes to absolutely do that. And
I'm seeing so many wonderful questions in the chat to us. Someone has asked, what if being a parent is a positive attribute for the role? Graham says, for instance, I hired staff a couple of years ago. Their primary role was supervision of a young professional team. During the interview, the candidate disclosed that they had children, and this was a positive attribute. So of course, candidates can disclose that information. It's really up to the candidate to do that. So there's a big difference between, writing on an application form, how many children do you have, and posing questions in an interview that allow candidates to draw on their lived experience, draw on their life experience to show what they can bring to the role. So I hope that answers that question. Someone has asked, when is the right time to disclose a disability in the recruitment process? That's a really personal decision. I think, when we looked at some of the court cases around this area, it's not unusual for candidates to actually decide to disclose later on once they've been hired, because it does make people nervous that will be a factor in the hiring decision. But really, if you have an accommodation policy set in place, then there should be a sort of pathway for prospective candidates to identify what their needs are, and that may be that they need to have, if it's let's say it's a 3-hour written exam, that maybe they need a break in the middle for whatever reason related to a medical condition. So there should be those processes available early on, but the candidate is going to decide when that's relevant and important for them to disclose that.
Okay, I have 2 questions here that are, honestly, all of these questions are great, and so nice to see what you're thinking about. So what would be the next best step to make sure my organization is compliant and respecting all the rules? So this is something where you could have a meeting with a lawyer on this topic. And, if you were coming to us on this, what we would do is we would have sort of an initial meeting to get a sense of what is it that you're doing. We would take a look at the policies that you have in place to make sure that all of those policies are meeting your obligations. We could talk about your hiring process and what that looks like, and whether that hiring process is meeting all of your obligations. And then, you know, if anything is missing, to fill in those gaps, or go over and say, you know, before you hire your next person, you should really update the contract that you send, because that's concerning to us, or you should really update the job ad. So, you know, that's the kind of thing where you can absolutely meet with a lawyer, meet with one of us, and go over those different elements. And we may say, you know, this all looks great and there's no change needed. You know, that does happen from time to time where everything is looking in good order. And it was just a check-in to see, okay, yes, everything is in good shape here, and no issues. So that would be the next step in my mind for you on that. Ways to avoid tokenism during the recruitment process towards a more diverse workplace. So, you know, I think this is a challenge. You know, in one ways, in larger organizations where you've already got diversity going and it's looking good, then I think there's a lot of value to having, you know, your hiring panel be a diverse panel, to really send a message of, we care about this, and here are the people, you know, that demonstrate that we care about this, who are thriving in our organization. In situations where you don't have that, where you're maybe hiring, you know, the first person, the first BIPOC candidate, I think that being honest is a really great approach to say, we really care about this, and this is something that we're working on, and we obviously don't have it perfect at the moment, but we're working on this. You know, if you want to be involved in this process, we would love to involve you, but we also know we have to do this work on our own. And here are steps X, Y, Z that we're taking, whether that be we've hired an EDI consultant to come in and do some training with us to address bias, or we've got a lawyer looking at, you know, what are the tools that we can use to help make our hiring practice more equitable, diverse, and inclusive. To be really upfront about, you know, here's something that we care about, and here's something that we're actioning, and we're letting you know about that now. It's not perfect, but we're really trying to improve on it.
Yeah, and if I can add, Maya, I think, you know, from an employment law perspective, the job description is such an important document, because that's where you look to make sure that there's a lineup between skills and what the actual duties include. And so if as an organization, you've taken the time to think through, why do we want more diverse candidates? How does that fit in with our business strategy? How does that fit in with our corporate objectives? What are we trying to achieve here? Well, if you connect those dots, you can include that in the job description. You can say, we're not trying to hire, you know, more women just because. It's because this is how we see it fitting in with a specific program or objective or our mission. And so then you can tie those as sort of hard technical skills into the job description. And that gives you an avenue to talk about that in the process. So to put it in a more concrete lens, you might say that lived experience navigating a specific social program, or a specific issue, housing, something like that. That might be something that comes up in your job description, and then you might look for candidates, whatever their identity, that bring that experience in. So really, employers who take the time to step back and connect the dots between EDI and mission are going to have an easier time bringing that through the whole recruitment process.
Yeah, that's a great addition. Okay, so there are a few questions that fit into the sort of immigration. Are you legally entitled to work? Are you a permanent resident zone? I think I see 3 questions. this is a really challenging space, and one where, you know, in order to actually advise, Claire and I would have to look at what's going on here, because it would come down a little bit to, is it a requirement of the job? You know, the size of your organization, these other things. Employers can require proof of eligibility to work in Canada. So that's something that the Human Rights Tribunal has said. There's been somewhat recent significant case on this around permanent residency, immigration status, citizenship. And ultimately you can require eligibility to work in Canada. But again, this is a zone that's very specific, based on all of the facts of your circumstances. So, you know, I don't want to provide a, you know, direct answer to say this is allowed, this isn't allowed, because we really would need to look at what's the context here. Yeah, Claire, I don't know if you've got anything you want to add.
No, I would just echo that, Maya. You know, the guide to the code that we've shared on the screen is really helpful. I will say that we're really lucky to have these publicly available resources, but on specific questions, you absolutely want to get specific legal advice because it's very fact driven. There are lots of different thresholds, and a lot of different cases will be sort of on a spectrum. And so we don't want to speak to very specific scenarios. But I'm loving these questions that we're seeing in the chat. I think there's one more that I wanted to pick up on because it's a topic that I think is really important in all of this. Someone is asking about, and I know that I think we're at time actually, so we'll start to wrap up here. But someone is asking about an organization where they're following all the rules, but they say, I find this doesn't leave space to get to know the applicants outside of what they've included in their CV. Do you have advice on how to make interviews more personable without introducing bias in the process? So that's such a great question. And I think something that Maya and I have talked about a lot as we were preparing this content is that these are hard topics, and folks are scared of making mistakes and scared of saying the wrong thing. And it really is a process that can't be siloed. We all need to be a part of the solution and part of these sort of organizational transformations. And so there still needs to be some humanity in all of this. And so how do you bring that into the interview process? So Maya, does anything come to mind for you on that?
Yeah, I was just looking at one of the example questions that I gave, which is a question that I like, which is sort of, tell me something about yourself that I wouldn't know from reading your CV. And I think that sort of question is a question that you could ask of everyone. So it sort of fits into that standardized mold of, we ask everyone the same questions, but that kind of question still allows space. So I get the challenge, and maybe what happens with that question is that it doesn't fit into, a rubric guide for grading, but it gives you some additional context, and maybe gives you some context as to, oh, that previous answer that they gave now makes a little bit more sense. So, some sort of a broader question that gives space that you could still ask of everyone. So it sort of meets that. But maybe, doesn't change every time.
Yeah. So I think maybe we'll do one more question, but I see that we are at time, and so I'll let Maya, is there one jumping out at you?
Well, there's one that I think we can get to quickly, which is can you provide a self-identification form? What we see often is, so on the job ad, it'll say candidates are welcome to self-identify. That's totally fine. Again, it's obviously the person's comfort whether they want to self-identify or not. I guess you could use a form. I would be thinking a little bit about Do you have the right privacy tools in place to ensure that whatever information that you gather is kept in the right way? Those sorts of things. But yeah, so long as it's optional, you can certainly ask, if people feel comfortable self-identifying, they can self-identify. And
I'll double down on that caveat that if you're in the federal stream and it's under a specific equity program, completely different scenario. If you're in Ontario, general Ontario business, different scenario. So in terms of what you're going to be asking candidates to disclose, it's very much going to be connected to the operations of your business and to your jurisdiction and to what is really needed in terms of your daily operations. Sorry, go ahead, Maya.
I just want to say if Jennifer, who has the special Section 14 program, is still here, to send us an email, because I do, it's a great question and I'd like to get to it for you, but I think it'll be easier to address that via email. So if you're here, send us an email and we'll write to you about that. I'm sensitive of time, so maybe we should call it there.
Yeah.
Thank you so much for these questions. And again, the information sheet that we'll be providing has both of our contact information on it. And please feel free to send us an email and get in touch.
Okay, wonderful. Thank you all so much for being here, and we hope to see you at our next session. Bye-bye.
Bye.